Hi, good afternoon, everyone, and good morning to those on the West Coast. Hopefully, everyone is out of bed and in some sort of home office situation, ready for today's webinar. My name is Dia Matthews, and I'm an immigration partner with the New Jersey office of Chugh LLP. I'll be facilitating the webinar today. Before we start, special thanks to Ty for organizing this webinar. As we know, one of the missions of Ty is to bring us all together as a community and to educate and share the resources. And so webinars like this are certainly in keeping with the spirit of Thai. Today's webinar focuses on immigration compliance in times of COVID-19. While these are tough times for everyone, there are special challenges for individuals in non-immigrant status, as well as their employers. So we have compiled a list of the most commonly asked questions, and we have here an expert panel of our stalwart immigration practitioners from the various offices of Chugh LLP. We will go over these topics, and we'll have a short Q&A segment at the very end. Now, before we dive into our discussion, let me introduce you all to the most optimistic person I know, our managing partner, Mr. Navneet Chugh. COVID or not, you can always count on him to find the silver lining in any situation. So I'll give him an opportunity to say a few words here. Over to you, Mr. Chugh.
Thank you very much, Thea. You know, I have a sign on my desk that says TTSP, this too shall pass, and this will pass as well. The world has been through things far worse than this. We will come out ahead. Times like this, we also have to think about how do we make lemonade out of lemon. And I think Thai members are good with that and used to it and will do so. Before all the wonderful immigration topics you're going to cover, I thought I should share with our webinar attendees that there are many good things going on that the Congress has done to help us, and states are doing, and government agencies are doing, and our members, our attendees should take advantage of all of that. For instance, 125 million people will get a $1,200 check. So look out for that. Good news if you get, also good news if you don't get, because if you don't get, that's because you're making too much money. So that's good. You don't need the 1,200 then. A bunch of tax deadlines are extended. You can pull money out of your retirement account if need be and not have to pay penalties. There's tremendous unemployment benefits for everyone that have lost a job or has got their job cut into part-time or hours. First time independent contractors will get unemployment benefits. There is a 2-week sick leave provision that the government will pay for, and also an extended 10 weeks FMLA. If you have a business, you don't have to pay the payroll taxes right now. You can pay half of it in 2021 and half of it in 2022. For some employers, they can get $5,000 per employee for not firing the employees. And there is a economic injury loan available up to $2 million for 30 years at 3.75%. But the most important thing I wanted to share, Dia, is that every one of business owners, every one of Thai attendees, members, should apply for a Paycheck Protection Program loan. Congress has enacted this under the CARES Act, and the government is saying, show us your payroll for the last 12 months and tell us what the average payroll is for a month. Add to it the medical and dental insurance benefits and retirement benefits, and we will give you a loan for 2.5 times that amount. Your monthly payroll will give you a loan for 2.5 times. And we will look back later, and if you've used that money for payroll and keeping your employees, and we will forgive the loan. So there's no reason why any business person should not be applying. So I encourage everyone to please apply, and don't fire people and don't cut their hours. You're allowed to cut salaries up to 25%. and still be eligible to have your loan forgiven. So any other questions or any help you need, please reach out to us. Thank you so much, Dia.
Thank you, Mr. Chugh. I think we should have a webinar on everything that you just talked about in the days to come. All right. So back to immigration. We'll get started. My first question is going to be to my colleague and attorney, Li Hua Tan of our Santa Clara office. So Li, if you're on, tell us a little bit about the status of the current H-1B cap season and whether COVID-19 has affected the current H-1B cap filings.
Sure. COVID-19 didn't impact the USCIS fiscal year 2021 H-1B cap selection process. On March 27th, the USCIS announced that the annual limit for fiscal year 2021 H-1B cap has been met, and the lottery selection process has been completed. It also notified petitioners with selected registrations by March 31st, 2020. There were nearly 275,000 registrations were submitted. Roughly 46% of those registrations were from prospective beneficiaries with the U.S. advanced degree. Nearly 81% of submitted registrations were for potential beneficiaries from India, which represented 67.7%, and China, which was 13.2%.
No surprises there, I guess. Sorry.
Yes, similar like previous years. The impact on employers' actual H-1B cap subject filings is yet to see. So if a registration is not selected and the status continues to show submitted, it will remain in consideration for selection until the end of the fiscal year, which is September 30th, 2021.
Mm-hmm. I see. Okay. All right. So business as usual. Can you tell us a little bit more about what to expect in the next few months and the process for filing the cap petitions?
Due to H-1B cap selection and the filing process change this year, the H-1B cap subject petition must be properly filed from April 1st, 2020 to June 30th, 2020 to the USS Service Center indicated on the relevant registration selection notice, which the employer received. Some employer reported that they received selection notices with different USS filing centers for different beneficiaries, even though they are from the same company. In such cases, we advise the employer to send the cases to the service center listed on the specific registration selection notice. And also, as the online filing is not available for H-1B petitions, the employers will need to file H-1B cap subject petitions by paper and include a printed copy of the applicable registration selection notice in the petition. The other issue is that on USS Direct Filing Address webpage, it requested the petitioner to put master cap or regular cap in the attention line. However, the selection notice didn't clarify the case was selected under master or regular cap. So when being questioned, the USS responded that employers should put the master or regular cap according to the category listed on the registration. So if a case is registered under as master cap, the employer will need to file it as a master cap case, regardless it was selected in master or regular cap in the process.
Okay, thank you, Lee. That was a very helpful overview. All right, my next question is to Attorney Gurshan Chata of our Santa Clara office. Gurshan, I hear there was some denials of cap registrations, erroneous denials, saying that they are duplicates. Tell us a little bit about that. What is USCIS doing about it?
Yes, good morning. These were about 10 days ago, someone noticed that they were erroneously denied over 100 H-1B visa registrations. However, since then, USCIS has responded stating that they were not erroneously denied. How it was denied because one registration was submitted by the petitioner themselves and the other was submitted by someone on their behalf associated with a G28. Hence, they denied the duplicate. So this is an ongoing issue where a certain representation have admitted that they did submit duplicates. However, certain are still contending that they did not submit duplicate registration. So this is an ongoing issue which will probably be solved in the upcoming weeks. There's speculation that if they were erroneously denied, they might open up another round. However, I believe that's a very unlikely scenario based on USCIS's response to this and their history of responding to issues like this.
Thank you. And my next question is probably an entire webinar topic in itself. But Gurshan, again, for F1 students who were not selected in the H-1B lottery, what options do they have now?
Yes, if they were not selected in this current lottery, one thing would be to complete their OPT training if they have any time left in that. The other would be if they have a STEM degree, they can pursue a STEM OPT, which will give them 24 months and they will get 2 more chances at the CAP lottery for the upcoming years. So that's something they can pursue. Another option would be if they've completed their bachelor's, they can pursue their master's, which will give them additional years to stay in the US and apply for the CAP lottery. So they'll get additional times to place their names in the lottery in the upcoming years.
Thank you. All right, I think we just got a question from the audience. This is on CAP, so I'll leave it to the panelists. Perhaps Lee, if you can take this. The question is, what if an employer doesn't file an H-1B petition despite having a case selected in the registration process? I suppose the question is whether there'll be any adverse consequences for an employer if they don't file the petition. What is your take on that?
So previously, the USS listed the answer to not filing. They are asking to, there's no updated answer from the USS yet. The previous answer is very generic. Just say that because if you don't file, there's no record at the USS side. So USS is saying that you keep all the record, and also we advise you that to keep the written record of the reason why you cannot file. If it's due COVID-19 reason, you need to document well and for potential audit. And also, we are still waiting for the USS to update on the process, on the procedure, or other kind of method to notify the USS of the reason of not filing. So we will get back to you if we hear any update from the USS. But right now, please document well of the reason why you don't plan to file.
Right. Thank you. Thanks, Lee. Okay, so we'll move on to the next question. And this takes us into the territory of H-1B compliance. We've been getting a lot of questions about this. Our next speaker is Attorney Hafiz Uddin from our New York office. Hafiz, so with most employees, including H-1B workers, working from home now due to the whole COVID situation, what all does an H-1B employer need to keep in mind?
Thank you, Dia. That's a great question. So generally speaking, no LCA or H-1B amendment is needed if the employee's residence, if the employee is working from home and the residence is located within what's called a commutable distance from the H-1B worksite, as would have been indicated on the petition and the LCA. A commutable distance is generally a location that's within the same MSA or reasonably any location that's about a 50 to 60 mile distance from the employee's home. In such circumstances, the employee may work from home, but they should post the LCA notice at their home for at least 10 days. And preferably the employer should also post on their electronic board or other locations as may be feasible. Alternatively, they can also email all affected employees. Further, the notice and should be placed within the public access file for the company as soon as possible.
Right. Thank you. And also tell us a little bit about the concept of short-term placement in H-1B parlance.
So the short-term placement option allows employees to work outside of the normal work site for up to 30 work days without filing any kind of an amendment or an LCA. It's noteworthy that it's 30 work days, so it's a little bit more than actual a month or so. But outside of that, you need to file an amendment for an amended LCA and an amended H-1B petition.
H-1B petition. Cool. Great. Thank you. The next question is for my colleague Brittany Simmons of our Santa Clara office. And the question is, with the general economic downswing, what are an employer's options for H-1B employees who do not have sufficient work or projects for the time being?
Hi, Dia. Thank you for the question. So the first thing to consider is whether there's a different position or another project that the H-1B employee can move to. So this could be at the end client site or in-house. The second option is to reduce your employee's hours to part-time. And by doing that, you would need to file an H-1B amendment and you'd still be required to pay them at the prevailing wage. But then you would be dealing with part-time work, so less salary overall. And then a third option is to file an amendment lowering their salary to the amount on the prevailing wage. So if your offered wage is higher than your prevailing wage, you could bump it down to the prevailing wage permanently. And if you're going to do that, I would suggest that employers issue another employment agreement and have it signed by the employee so that you have in writing that they've agreed to take this pay cut. A third option also exists, but it is very temporary in time, so it's a short period of time, and you would have to do this for your entire workforce. So with that, you can cut the salary and the hours so long as it's still full-time. And with that salary cut, you still, for your H-1B workers, it has to be at or above the prevailing wage on the LCA. Okay.
So I guess what I'm hearing from you is that an employer can definitely reduce the work hours or the wages as long as of an H-1B employee, as long as an amendment petition is filed.
Yes, that's correct. And if it's going to be a short term where it's just a few months to ride out this pandemic, then you may not need to file an amendment, but you should consider all your options before proceeding either way.
Okay. Thank you. All right. We just received a question from the audience, and this is related to what you and Hafiz just discussed. So I'll open it up here. The question is, our H-1B worker went to India for stamping and they're stuck there. They are now working in India. Should we file an LCA or an amended petition for that person? Brittany or Hafiz, if you could answer that. The question is whether you need to file an amendment petition for somebody who's for an H-1B employer who is working from India because he or she is stuck there and unable to travel back.
Hi, Dia. If I may, I'll try that question. So if the employee is not in the US, not really subject to the US requirements, I would say nothing needs to be done if they're not in the States right now. If the employment happens in the States, then the LC obligations do apply.
I agree with you. Thank you. All right. Thanks, Hafiz and Brittany. The next question is to Attorney Navdeep Miambar of our Santa Clara office. And this is a specific question on the H-1B LCA posting regulations, right? So now the rule is that an LCA has to be posted for 10 days at the employee's worksite. But with most offices being shut down and people working from home these days, how is an employer expected to comply with the LCA posting requirement for H-1B petitions?
Yes, Dia. So if you are one of those H-1B employers who is unable to physically post the posting notice at the work location, the Department of Labor has clarified that H-1B employers can provide electronic notice of an LCA filing under the regulations. So for electronic notice, the employers can comply by using any of the ordinary methods they use to communicate with these employees about the job openings. They can post it on their website, they can do it on their intranet, they can do electronic newsletter, or they can even send an email. So if they comply with any of these electronic methods, just make sure that you take a printout and put it in your public access file to tomorrow if you need to show to Department of Labor or USCIS that the compliance was done. So one of these methods should be good enough if you're unable to physically post it at the work location.
Right, right. And I believe Department of Labor has also given a 30-day extension, right, for the LCA?
Yes.
Yeah.
Yes.
Okay. I had an interesting question from someone last night, and the question was, oh, we want our employee to post the LCA at his home because he's working from home now, but he doesn't have a printer at home. So what do I do? And I think the quick answer to that would be just, mail the employee a printout of the LCA and have him post it, have him or her post it at home. Okay, all right. Another question to you, Navdeep. And this is again on H-1B employees. So for H-1B employees who've been laid off from work because of the COVID-19 shutdown, can they continue to stay in the US until the travel ban in their home country is lifted? So I guess, common example of somebody not being able to go back to India, for example, right? They no longer have employment in the US. Can they just hang around in the US?
Okay. So currently, we do not have any instructions that such people who are unable to work at the work location mentioned in their LCA and H-1B, and they are unable to travel because of the travel ban, that they are not in violation of their non-immigrant status. So in the absence of such instructions, we are highly recommending and advising our clients to file for a change of status to B2 visa, which can be easily done by filing a form I-539. With USCIS. So filing of this form and changing request to B2 visa will give them time to see how the government responds to such situation where H-1B employees are unable to work and also unable to leave. So just tomorrow, if questioned at some point about their status, they can show that in good faith, they did file for change of status and, took some action. So please do not just stay and just assume that you are okay to stay. You want to take some action and try to file change of status.
Right, great, thank you. All right. Next, we'll go to my colleague, Deepika Singh of our Santa Clara office. Deepika, what precautions do you think an employer should keep in mind when terminating an H-1B worker?
Thank you, Dia. So there are a lot of beneficiaries on some visa categories like the E1, E2, E3, H1B, H1B1, L1s, O1s, and TNs are granted the 60 days grace period when their employers are terminating their services. So discussing specifically for the H1Bs, they have a 60 days grace period to file another H1B transfer with a new employer. Now, as an evidence, the employer should give them a terminating notice, which can be used as an evidence to utilize the 60 days benefit when they are filing their H transfers with the new employer. Now, the terminating employer must offer transportation costs back to the H-1B's home country or country of residence. This offer should be made available for a stipulated time, and given the option, the H-1B beneficiary can accept or decline the offer. Employers may also choose to send withdrawal letters to USCIS informing them that they are no longer sponsoring these H-1B beneficiaries, and keeping documentary evidence of these terminations is a good practice. Also to add, employers are not obligated to offer employment at their overseas entities if they don't have any such policy in place. Over to you, Dia.
Okay, thank you. All right. The next question is to Kirti Kalra from our Bay Area office. Kirti, can an employer continue to make some payments to an H-1B employee even after termination? Just to explain that further, what options are available if an employer wants to financially help the employee who's unable to leave the US and is, kind of stuck in the US?
Hi, Dia. Thanks for the question. Let me start by saying, well, there are many options before terminating the employee in the first place by assessing so many loans available to businesses of all sizes due to the stimulus package. We put out many webinars discussing these loans, and I'm sure we will continue to discuss these for the near future. But in the event you do decide to terminate the H-1B employee, there are a few options you can, which allow you to continue to support them financially. So you can issue them severance pay. It's a manner which many terminated employees are afforded time to recoup, reset their careers, and find some relief as they look for new jobs. So that's one. And the other options are to provide them short-term loans from the US entity or the foreign entity of the employee's origin, if you guys have an office there. But just a couple of things to keep in mind when you have to be careful when providing loans to employees. you always want to get your payroll provider involved or your accountant involved to make sure that you're doing this properly. And as for the severance pay, this may be an opportunity for the employee to show some mutual appreciation as well. The employer can request, a release of potential employment claims that may possibly exist at this time.
Okay, thank you. All right. So the next question is again on H-1B maintenance of status. The question is, do H-1B employees have to be paid their salary even if they cannot continue to work because of a COVID-19 related shutdown at their work site?
Right. So if you do not terminate the H-1B employee in this situation or file an amendment to relocate the employee somewhere else, either way, you have to continue to pay this employee the wage that they're due.
Mm-hmm.
Otherwise, otherwise you'll be essentially benching them, which is not permitted. And there's no guidance on this being an exception.
Right. So yeah, and I know that everybody's asking us this question practically every day, right? My take on this is that if the employee requests the time off, then it's okay. They can take unpaid time off. But if it's because of the employer or the client or reasons outside the control of the employee, then that's not permitted. They have to be paid.
That's correct. I would agree.
Right. Okay. Thank you. All right. Next, we'll speak with Jagan Tamirasi of our Reston, Virginia office. And the question to Jagan is, has premium processing been suspended and for what kind of petitions?
Thank you. Yes, the premium processing has been suspended for all types of I-129 petitions, including H1, L1, O1, R1, TN, and others, and as well as for I-140 petitions. This is a very significant development affecting all the employers, as well as the USCIS too, because USCIS collected nearly $545 million in 2019 fiscal year through premium processing fees. And that's a significant loss of revenue for an agency that's funded only through the fees.
Right.
Premium processing suspension means, obviously you cannot expect a decision in 15 days when you file a case. And there is no indication from the agency when they will reinstate it. So at this point, if you have a petition that you need to file, please continue to file the applications on a timely basis. Do not wait or hold for a premium announcement because we are not sure when that's going to come back. Delay in filing can affect employment authorization for certain non-immigrants. Presently, H1, L1, and other non-immigrants who have timely filed their extensions can work up to 240 days beyond the I-94 expiration date. But that also could prove to be insufficient because of the pandemic. And we are not sure how long this is going to last. So unless USCIS creates an exception for these categories, those people must cease employment after completion of 240 days. Therefore, it makes sense that the applications be filed as soon as possible so that you get a timely adjudication. There is obviously USCIS service centers are operating normally. They're accepting petitions. And if the petitioner is able to get the physical checks and send it over to the attorney's office, attorney can file it and get it to the USCIS, and it should be done on a timely basis. Delay can also cause uncertainty to those facing issues with maintenance of status, especially those who are in 60 days grace period and trying to move back to new employment. So therefore, the other aspect is they also have suspended premium for I-140 petitions. So what that means is obviously a EB2, EB3, if your priority date is going to be current or is current, and there may be a delay in getting your green card because your I-140 is either not approved or your interview has not taken place. If you have filed a premium and it has been accepted before March 20 and you're not yet to get a decision on the case, there's a possibility that USCIS may refund the filing fee because they may not be able to meet the 15-day deadline. Therefore, our advice is, once again, is not to hold your cases just because premium is not available, but please file it regular. If you are a petitioner facing an emergency, you may ask for an expedite request with your petition. You need to meet certain criteria for expedite requests, such as severe financial loss to a company or person, urgent humanitarian reasons, or compelling government interest. But these are pretty hard standards, harsh standards to meet. And unless there is an exception, and you can also imagine how many expedite requests can come in a daily basis. So it's not, one should not expect that expedite requests will be routinely be accepted. Back to you, Dia.
Right, that has been my experience as well. All right. So I think you spoke about it briefly, but are there any other steps that you think an employer should, proactively take right now with the suspension of premium processing?
Yes. So the practical aspect is identifying cases that are going to be expiring soon. You have a 180-day window to file your case on a timely basis. You need to make sure that you identify your applications that are going to be expiring within the 180-day window and try to file them and get them to USCIS as soon as possible. Make sure that you have tried to give them the initial evidence as much as possible to make a case, so as to avoid an RFE, so that your case can be approved back on time. Like I was also saying, some applications can also get tagged with H4 EAD and L2 EADs. Those people who even file an extension before these EADs expire, they don't get automatic extension of EAD authorization if the EAD card expires. If their card expires, they need to wait until the renewal comes in. So if you're tagging an EAD such as H4 or L2 with your H1 or L2, L1, please make sure that it's also filed very much in advance.
Right. Thank you. Thanks, Jagan. We just received a question in the chat, and because it's related to this topic, I'll just read it out. The question is, we have an issue with an employee and her extension was filed. Okay, so the question is that I guess it's an H-1B extension that is filed in regular processing and a decision has not been issued yet. Given that USCIS is slow now, any way for us to follow up with them to try and expedite it? Okay, I'll take a stab at this. I think so. I suppose in this question, the person is going to approach the 240 days, which is the amount of time that you have when a case is under adjudication. Generally, I think USCIS has said that they would try to expedite the cases. They prioritize the cases which are approaching the 240 days. So it might help to just place a service request, because when they do a sweep, I think at 180 days and then again at around close to the 240-day mark. So with premium suspended, that's something that we can do outside of the expedite, just raise a service request.
Dia, just wanted to add that probably in 2018-19, when the premium was suspended for H-1B amendments and transfers, and case processing was getting delayed, at that point, USCIS did say that those who are approaching the 240-day mark should bring special attention to USCIS so that they can approve it on time before the 240 days pass. So it's possible that option still exists now. If you, like you said, if the service request is placed, it's possible that the case can be processed fast.
Yeah. As long as they don't choose to issue an RFE at that stage, we should have an approval.
That's right. Yeah.
All right. Thank you. Next question is to my colleague Angelita Chavez of our Los Angeles office, and the question for you, Angelita, is: can an H-1B or an L1 employee apply for unemployment benefits from the state?
Thank you for that question. So in general, H1 and L1 employment is employer specific. So these employees are not eligible to apply for unemployment benefits as their employment is tied to their sponsoring US employer. This is because in most states, in order to qualify, a person has to be free, willing, and able to seek employment. An H-1 or an L-1 employee cannot claim unemployment benefits as they lack this freedom to work. However, depending on state law, an H-4 visa holder with employment authorization may be eligible to claim unemployment benefits if they have lost their job. There are some specific requirements for these H-4 visa holders. The H-4 visa holder has to have a valid EAD, and the principal H-1B beneficiary must also be in status at the same time. On top of that, the EAD has to be valid throughout the period that the unemployment benefits are requested. So individuals that have lost, who have EADs and have lost their jobs should contact the Department of Labor in each of their respective states to find out if they're eligible for this employment benefit. It's important to note that the Department of Homeland Security does not list unemployment benefits as a benefit under the new public charge rule, which makes it inadmissible for green cards, folks that have received federal benefits or aid. However, I do want to caution that as immigration is an ever-evolving area of law, we do not know for certain the potential future consequences of seeking unemployment benefits while on non-immigrant status. Back to you, Dia.
Thank you. Thanks, Angelica. And a related question, can non-immigrant workers take advantage of the COVID-19 stimulus benefits offered by the government at this time?
Yeah, so that is some positive news. As Mr. Chugh was mentioning earlier, the stimulus package is over $2 trillion, and American workers are able to benefit. And thankfully, non-immigrant workers in the US are also able to take advantage of the stimulus packet. So these workers, in addition to other categories like DACA and TPS workers who have valid employment authorization, may also benefit. The stimulus package includes a $1,200 check for American individuals. These are heads of households, and $500 for their dependent children based on either their current taxes or their 2018 taxes if they have made less than $75,000. Married couples will receive $2,400 if they made less than $150,000 in adjusted gross income. So if folks have not done their taxes or their current bank information is not available online, let's say they've changed banks or they've changed bank accounts since their last tax filings, highly encourage folks to do their taxes and make sure all the information is straight, is up to date with the IRS. So that way, when the checks start to become available, hopefully in the next 3 weeks or so, for those that are getting direct deposit, that money is going to be going into the correct bank numbers. Otherwise, it will take much longer for folks to get their checks as they will be mailed out to the last known address that has been on file.
Okay.
Yeah.
Thank you. So some good news there. That's
yes.
Good. All right. Moving on to my colleague, Melissa Chan of our Bay Area office. Melissa, the question for you is, will applying for SBA loans, such as the Paycheck Protection Program or the EIDL, or will that cause any problems for employers filing H-1B petitions or green card petitions?
Thank you, Dia. The response is not necessary, as the stimulus loan program to the SBA are specifically designed to help small business adversely affected by the COVID-19 to preserve status quo, i.e. continue to make payroll to their employers at current rate, as well as cover key expenses such as rent, utilities, and etc. The ability to pay the H-1B worker is met when the H-1B employees receive the wages as listed on the H-1B petition. For green card holder, this is a future job offer when the sponsored foreign national receives his or her green card. Due to the retrogression of priority dates, especially for Indian nationals, the employer has time to address this. If the foreign national is already making the wages listed on the GC application, then the employer has met the ability to pay criteria.
Right. So no issues with applying for these loans, right? Feel free. Okay. Thanks, Melissa. I think it, it kind of reminds me of this, the situation in 2008, 2009 too, when, the banks took the bailout funds. I think there was a specific provision when they were getting bailed out that they should not be sponsoring H-1B employees. And so for a while, that's why the banks, the big banks could not sponsor H-1B employees. But this is different, with the whole COVID situation, there is no, there's no restriction. And, it should not have any adverse impact on the ability of an H-1B employer to file an H-1B petition or sponsor a green card. All right. Next question is for you too, Melissa. Actually, there's a bunch of questions. So are the Paycheck Protection Program and the EIDL loans extended to US businesses owned by green card holders? And second, can these PPP loans be used to cover payroll for H-1B and OPT employees?
As to the first question, yes, as long as the business affected by the COVID-19 meets the SBA definition for small business, i.e. organized for profit, has a place of business in the United States. As regard to whether PP loans can be used to cover H-1B and OPT employees on payroll, yes. Under the Paycheck Protection Program, 75% of the loan must be used by the employer to cover all employees on its payroll, with the balance being used for office expenses such as rent, mortgage, and utilities. If you have any questions regarding SBL loans, please contact our accountant practitioners who will be happy to help you address these issues.
Thank you, Melissa. We just received a question on whether U.S. businesses owned by H4 EAD, or somebody in using the H4 EAD, whether they can also avail of the the SBA loan. And I guess, as you said, they're not looking at the ownership of the entity. The question is whether the entity is a U.S. entity, and that's what determines the eligibility. Okay. All right, great. Next question is to my colleague Gladys Gervasio of our Los Angeles office. And the question is, Gladys, does the COVID-19 pandemic affect the ability of companies to continue with the green card processing for their for their foreign national employees? Has it in any way affected the ability?
Hi, Dia. So when it comes to the PERM or labor certification process, we know that there are two competing interests. That's the employer wanting to hire a foreign worker, and other is protecting the US workers, right? And one of the attestations in the PERM application is that the employer has not had any layoffs in the last 6 months. So if you had to lay off US workers because of this COVID-19 pandemic, it may affect your ability to file PERM applications. Now there are ways to manage this. You want to ask certain questions like, were the laid off employees US workers? Were they working in the area of intended employment, or were they working in the occupation or related occupation as set out in the PERM? So there is a need to make an analysis on this one, and it would be best to discuss this with your immigration attorney. Dia?
Thank you. Thank you, Gladys. And Gladys, could you also briefly talk to us about the Department of Labor's response to the whole COVID-19 situation?
Sure, Dia. So the Office of Foreign Labor Certification, they will grant extension requests to respond to an audit or a notice of deficiency. Basically, all requests for information that has a deadline, they will consider and grant an extension. And if your deadline falls within March 13 through May 12, your response will be considered timely filed if received by May 12. With respect to PERM recruitment activities, if you cannot complete them within the 180-day time frame, you'll have an extra 60 days after the deadline to complete recruitment. The same is true for the PERM notice of filing. Note that the 60-day extension applies if you initiated recruitment within 180 days preceding March 13, and that's the date of the President's National Emergency Declaration. But if you've completed recruitment during the 180-day time frame, you should still proceed to file your PERM application under existing regulations. Lastly, if you're filing an amendment because your H-1B employee is now working in a location that's not within the area of intended employment in the LCA, and you've used up the short-term placement provision as discussed by Hafiz earlier, then you can post your LCA within 30 calendar days from the time your H-1B employee moves to the new work location. And that would still be considered as timely posted. Back to you, Dia.
Okay, thank you. Thank you, Gladys. All right, I think we'll have one more question. And I'll ask my colleague Deepika to answer this. So Deepika, we hear that some kind of, well, a lot of the in-person services have been suspended by USCIS, but what exactly is going on there? Has USCIS shut down completely?
So, Dia, to answer your question, USCIS has not shut down. The service centers are still operating. They are still adjudicating cases. However, any in-person services like asylum interviews, naturalization oath ceremonies, biometrics for I-539s. Those services have been temporarily shut down, and USCIS will consider reopening their offices by May 4th. The good news is that 765 renewals and extensions, whoever has filed these cases, they will use the pre-existing biometrics and the fingerprinting and adjudicate those cases further. So the 765 EAD renewals will still be processed with their old biometrics. Other than that, any in-person routine has been kind of, stagnated for now.
Right. Okay, thank you. And we've been, a lot of people have been asking, so if the interviews are not happening, for example, the employment-based, the final stage interview, since many of them are getting canceled, is there a chance that the green card can be approved without the interview?
They have said that they will be issuing renewal, other notices for future interviews. So I think we'll have to just wait for USCIS to come up with that.
Right, right. I think we heard some anecdotal, the instances of some cases getting approved without the interview. But of course, I think even if that happens, it will only be for employment-based cases. They're definitely going to interview all the family-based applicants. So those, would definitely have to wait.
Right. But I'm seeing that USCIS is adjudicating all the H1s and the L1 in their timely manner. So I think we just have to wait for the May 4th to hear back when they are going to open their inline offices,
Right, right. Thank you. All right. So I think that brings us to the end of the prepared questions. We can now, take the questions from the audience. I think we already have a few in the pipeline, so we can go over them quickly. We will not be answering any case-specific questions, obviously, because that would go outside the scope of this webinar. Everybody's, free to contact our office if you have any specific questions on your individual immigration situation. But we will only answer questions of a general nature on this webinar. So we have some good questions, some of them related to the topics that we discussed earlier, and I'll just go over them one by one, and the panelists can choose to answer. All right. So this question is: if employees are working from home and they get a new project confirmation for some other state, is an H-1B amendment required? So I believe the question is, the employee continues to work from home, right? So let's say that's in New Jersey, and the client or the project that they were working on used to be, let's say, a New Jersey project, but now they will be working from New Jersey for a client in California. So is an H-1B amendment needed in that situation? Any other panelists? Hafiz? Can I call on you?
Hi, Dia. So let me see if I get this question correctly. What was the worksite location indicated?
Yeah, the worksite is the employee's home, right? And let's say in New Jersey, and it's just that the client, the end client for for whom he or she is working, that has moved from, let's say, New Jersey to California. So example being, let's say they were working for Johnson & Johnson in New Jersey, but now they were going to be working for Apple in California. But the employee is working from New Jersey. So is an amendment required in that case?
What is the worksite indicated on the LCA and the original approved petition?
I would assume it was New Jersey.
If it's New Jersey
But the employee is still working from New Jersey, right? It's just that he's working on a project for California.
So if the productive work is being done from within the MSA or within the commutable distance of the worksite location,
right,
I don't think that anything further is required.
Right, I agree with that too. I think we've had cases like this where the project or the client might be elsewhere, but the employee's work location actually hasn't changed. So in that case, even after the whole Senior Solutions decision, an amendment is not strictly required because the work site remains the same, which is the employee's home. I guess I know that some practitioners feel differently. They feel that because the work has changed, the project itself has changed, that can be considered a material change. And so it might be a good practice to do an amendment. But, as a practical matter, we've had, I guess, cases which were approved even, where an amendment was not filed in that situation.
Correct. If the underlying petition specifically indicated that this person would be working for a particular project, then you may encounter the material change
Right.
If that's not the case, then I think you're fine.
Right. Thank you. Thanks, Hafiz. All right. So the next question is about employee requesting time off. So the question is, if an H-1B employee has requested time off, and the employer chooses not to pay them for this, for this time that the employee requested off, is there a maximum period of time that the person can be out of work, like 30 days or 60 days? Anybody want to take that? So the question is, how long can an employee choose to remain unemployed? So this could be, for I guess the typical situation is an employee wants to take time off for maternity, right? And it might be 2 months, it might be 4 months. Is that allowed? So in general, the answer is that it's okay as long as the request comes from the employee. It shouldn't be disguised benching. That's what Department of Labor and USCIS are looking to avoid. So as long as it's not benching, it's not because the employer doesn't have work, it's because the employee has requested time off for a personal reason, that's fine. As to how long this can continue, I mean, I don't think there's a bright line rule for that. I think you have to look at the, the specific situation and see if somebody needs time off for an extended, medical procedure or, medical treatment. There's no restriction. You can't say that, oh, you have to come back within 30 days or 60 days. So it really depends on the, the facts of the specific case. And, as long as the employee can substantiate that it really was a reasonable request for their personal reason.
And Dia, if I could add to that,
Yes.
I think you make a great point. I think one thing to be cognitive of is that you want to be able to document the reasons for unpaid leave. If the employee's taking PTO, there's really no issue. But if you're taking unpaid leave, and to be assured that, in case of a DOL audit or a USCIS audit, that it will not be considered benching, you would want the employee to document all of this for you as to why you're taking the leave. For example, like you mentioned, a medical procedure, that is a good and a okay reason to take unpaid leave. You would say, you would document that the person, say, for example, had a surgery, they need 60 days off, and it's been doctor approved.
Right. Exactly. I'm so glad you brought that up, Kirti. Documentation is very important, especially in today's world. I think Department of Labor said that they don't really give much deference to, these blanket leave letters. You might, from an employer perspective, I think there's more, you should protect yourself by getting some documentation around the request. Thank you.
Absolutely.
All right, just going over the questions. All right. I think we had a question on maintenance of green card status, and that came in earlier. So the question was, as a green card holder, if a person is stuck outside the US for more than 6 months, right? They're not able to travel back to the US, because of airline, restrictions and things like that. Is there a problem? Will the person lose their green card if they remain outside the US for more than 6 months? Gladys, do you think you can answer that?
Oh, sure, Dia. So if you stay outside the US for more than 6 months, but less than 12 months, there's a presumption that you intended to abandon your lawful permanent resident status. But that presumption can be overcome when you re-enter the US by showing that you never had that intention to abandon. And with this COVID-19 pandemic and the travel restrictions that you mentioned, the port of entry officer will likely take that into consideration. And I would say perhaps they'd be more lenient than usual, but at the same time, you still want to be able to establish your significant ties to the US, show that you're maintaining a home, that you have your utility bills, your employment documents, that you filed your tax returns, and you have your US bank statements, so which you should be ready to present at the port of entry if you get questioned. But I think the key here is that as soon as the travel restrictions are lifted, then you should return to the US as soon as possible. What's your take on that, Leah?
Yes, I think, generally the obviously, if you want to preserve the dates for naturalization in order to apply for citizenship upon completion of 5 years, you should be able to demonstrate that you've not been outside the US for more than 6 months in the last 5 years. But if you were stuck outside for a reason beyond, your control, right? Then you can explain that. And it has to be, the number of days that you were stuck outside has to be commensurate with the reason that you're giving, right?
That's right.
So I remember a few years ago when there was that volcano over Iceland, right, which suddenly became active, and because of that, a lot of flights to the US were getting canceled. So a lot of people could not, make their pre-scheduled trips back to the US. And like some of them were maybe stuck outside for 7 months, etc. But as long as you can explain what the reason was, and demonstrate that you did not intend to abandon your residence in the US, USCIS will accept that. You have to document it, and you probably have to give a good explanation around it. But just a few days, because of the COVID situation, would be, I think that USCIS would understand that, and they would forgive that delay.
Yeah, can I add a little bit to that?
Yes, please.
Yeah, sure. So the situation will always be an issue up until you apply for citizenship. So let's say 20 years go by and you apply for citizenship and you were outside of the US for more than 6 months, it will be an issue when you apply for citizenship. So the documentation of your reasons why you were not able to return and why they were outside of your control is so crucial and so important, because it will come up even if it's 20 years later. I've seen it time and time again, where folks think that they don't have issues anymore. It's been 20 years, but it will come up at the time of your citizenship application. So documentation is key. And of course, as you mentioned, it has to be commensurate with the reasons why, your time should obviously, everything should actually match, right? So I just wanted to add to that it will be an issue at the time of applying for citizenship, even if it's 20 years later. So documentation is
very true. Again, documentation. Thanks, Angelita. Okay. So a few questions, I think. Okay, one more question. We kind of touched upon this, but we'll just explain this again. So the question is: must an H-1B amendment be filed for 2 H-1B employees if all of our employees take a 20% pay cut as a result of the COVID situation? So I think Hafiz, you had touched upon this, right? About H-1B employees being included in the general pay cut. Was it you or was it Brittany? I think one of you had spoken about this. So the answer is that yes, an H-1B amendment must be filed. You can reduce the wage or the number of hours, but if it goes beyond the term stipulated in the initial petition, then you should file an amendment.
Correct. Yeah. Thanks.
Thank you. Okay. So should we now open it up to questions from the attendees? Yeah. Sasha, so I think we have a question from the audience. All right. Can we take the first question? I see some hands being raised. Swati Patel, I believe.
Yeah.
Yes, go ahead.
Yeah, so my question was like, I had filed my H1 around February, and then I have got an RF. It was in premium process, and then I have got an RFE towards it. So possibly the due day is around May 7th May. So I was not sure what are the probabilities of approval or rejection towards it, and how will be the situation towards it, and what would be the actions or cautions that has to be taken.
Yeah, so Swati, because this is a specific question about your individual case, we will be happy to schedule a discussion with you separately outside of the webinar.
Sure.
Okay, thank you. I think we had a question on O1 visas while we get ready for the next, question. This is just something that came in earlier, a question on the O1 visas. I think this is again a category that's not explored often enough. So I'll ask my colleague Deepika to say a few words about the O1 visa.
Thank you, Dia. So Dia, O1 visas are also employment-based visas. They are sponsored by a US petitioner. They do have the 60 days grace period if the employment is terminated. If somebody wants to transfer the O1A visa to another employer, they have to file a petition with USCIS. Till the approval doesn't come through, you cannot start working for the new employer. So pretty much similar to, to an E3 visa or a TN visa when filing for a change of employer situation. So anybody on an O1A terminated has 60 days to depart the US or can find another employer and file the O1A transfer. Thank you.
Thank you. And can you also talk a little bit about, what a person needs to do to qualify for an O1? Just very briefly, Deepika, if you could talk a little bit about it.
So O1 visas are, there's an O1A category, which is pretty much for people who are extraordinary ability, meaning that you have industry recognition, very similar to the EB1A, where, you kind of are like an industry guru. You have some specific knowledge, which is of great economic benefit to the employer. And, you have some, you are unique in your field. So anybody who has some kind of for example, somebody who's a data scientist, they definitely qualify for an O1A, So anybody who's kind of extraordinary in their field can apply for an O1A, and a US petitioner has to sponsor the O1A visa.
Okay, thanks, Deepika. All right. Okay, I think that brings us to the end of our allotted time, because we are on the 1 hour mark. But if we have people who want to ask some questions, we're happy to stay on and take maybe a few more, just maybe a couple more. So I see Bala Itikirala. Would you like to ask a question? You need to unmute yourself.
Yeah, sorry. My name is Bala Itikirala.
Yes.
Actually, my question is, as you all know, many employers, they have received I-9 inspection notices around the second week of March, and USCIS ICE has given automatic 60-day extensions.
Yes.
Yeah, I was wondering, is there anything in the law that we need to maintain the original I-9s, or let's say at the time of the joining of the employee, if we scan the original I-9, let's say if we lost or misplaced, or the person who was the custodian is no longer working in the company, and they have the knowledge of those documents. So is it mandatory to show the original I-9s by law, or if we store them in the electronical form, is it still okay to produce?
That's a good question, and I hope you probably have attorney representation for the inspection, right? So we'll just keep it general. We won't get too much into the specifics, but in general, yes, when ICE issues a notice of inspection, you have to show the original I-9s. They might ask you to make a photocopy of the documents and provide it to them. In some cases, they just take the original files and they return it after they're done with the inspection. But the fact that it's misplaced, or the employee who was in charge of the documents is no longer around, that is usually not a valid reason to be excused from showing the original I-9s. Okay. All right.
Okay, thank you.
Next question is from Aparna.
Yeah, hi. Thank you for doing this. It's been very helpful. With the COVID being, being there now, the clients are changing the way they do business. So they are only giving incremental POs. So with that said, how do we best represent for H1 renewal? How do we navigate that? requesting for the extension periods and things like that?
Right. Great question. And if we had an easy answer to that, I think we'd all be millionaires by now. But I'll let the panelists take that question. So the question is, how do we manage these the short-term POs and work orders that are now being issued in the consulting industry? Kirti, would you like to take that?
Yes, sure. What we have done in the past is to show a pattern. The short-term SOWs has been an issue with the IT industry for a while when it comes to filing for H-1Bs. What we have done, and sometimes successfully, sometimes not, is that showed a pattern, whether it's in the initial filing or the request for evidence, that these short-term SOWs are just a way that the industry works, and it's not an indication of the project itself ending. So we just show a pattern that this is how this is done, and they have renewed it in the past, and they will continue to do so in the future. And aside from that, there's been a lot of.
Sorry, for those who are not speaking, if you could please mute your line.
So that's so in the.
Sorry, please. I think somebody's not muted their line. If you're not speaking, please mute your line. Okay, all right.
Yeah, I just wanted to add that one last thing was that this has been brought up to the court system as well, and the court system has made a decision that USCIS needs to have a better explanation of denying petitions without proper reasoning, because they're setting the bar up really high in order to approve H-1Bs, such as providing proof that there's work for the entire period, and there's like the amount of documentation has gone extreme. So this is in the court system, and hopefully this will loosen up the requirements. But as of right now, just showing a pattern is all we've been able to do to tackle this, sometimes successfully, sometimes not.
Great. Thank you, Kirti. On a related note, I think somebody also asked whether the recent slew of district court decisions that we've had, which have gone against USCIS and in favor of the plaintiffs, right? So there were decisions on USCIS interpretation of specialty occupation, on how they look at these SOWs and use it to determine the approval duration. And in all of these cases, that the district court held that USCIS was wrong. This is not how the regulations should be interpreted. The question was whether we expect to see a dramatic change in the current adjudication trend as a result of these recent district court decisions.
Yeah, also to add one point to that is that, see, we don't have control over these short-term POs and SOWs, but what the employer can do is, in case the case gets approved for a little lesser duration, they can make an LCA for a valid of 3 years, and then use the same LCA to file a continuation of application petition, right? That way they don't delay, and they can get another application into USCIS system ASAP. So probably that could be utilized.
Right. Yeah. Oftentimes, we end up using the same LCA because of the short-ended approvals. You're right. So yeah, going back to the district court decisions, my take on that is, these decisions obviously, they help, and we do. I think most practitioners will be citing them in the RFE responses and things like that. But again, it's not that they're binding on USCIS in general. Usually the district court decisions are binding only in the particular territory that they apply to. So I think they will have a persuasive effect on USCIS, but they're not binding on USCIS. The other thing that we expect is also that USCIS has said, I mean, the administration has said that they will also be making some regulatory changes to the whole definition of specialty occupation, and things like that. So, that might happen too from their end. All right. I think we have a question, one more question from Mr. Ashok. Yes, go ahead. Sorry. Okay. All right. While we wait on him, Amardeep, I believe, has a question. Yes. Go ahead, Amardeep.
Hi, good afternoon, everybody. Thank you for this session. It was really helpful. My question, I know we've had enough discussion on the H-1B employees that we have, but I just want to clarify what I heard on the webinar is that if we have an H-1B employee and the customer has asked the H-1B employee to work for less number of hours in a week, say 32 hours in a week, or if the customer is announcing a shutdown for a week or two, the employer, as in we still have the responsibility to continue the salary for the H-1B employee. Is that correct?
Yes, that is correct.
Okay. And the second question related to this is that if it is for a shorter duration of time, we need not refile the case. Is that correct?
No, that's not. I think the point was about reusing the LCA.
No. So I heard that if it is for a shorter duration of time, in the sense the reduction of the hours for an H-1B employee, or for example, if it is a shutdown by a customer for a week, then the H-1B need not be refiled for that employee with the new salary if it is just for a matter of a few weeks or a few months.
Yeah, I think it's getting a little specific. So, we'll keep it general because we don't want to be, giving out advice without understanding the, the complete facts of the situation, right? But just, going back to what the panelist has said, I think the main thing that they were underscoring is that if there is going to be a reduction in hours or wages, which is not caused by the employee, right? It is caused by either the employer or the, the client. You would have to file an amendment in order to do a reduction in hours or salary. Okay. If you have a specific question on, for a specific employee, we are happy to, discuss separately with you outside of the webinar.
Sure. Thank you.
All right. All right. I think that brings us to the end of all the questions and to the end of the webinar. Thank you again to everybody who listened in. Thank you to our panelists. And once again, thank you to Ty for enabling this. Have a good rest of the day, everyone.